We go to LT 931718, plaintiffs Woodhaven Terrace LLC, defendants Clifford Jefferson L. Bay. Your appearance, counsel?
Thank you, Your Honor. Alex Klein, Steyer and Leibowitz on behalf of the plaintiff.
Let's have the witnesses sworn in case anybody's got any testimony.
Place your left hand on the Bible, raise your right hand. State your name for the court.
Sheik Clifford Jefferson L. Bay, incorporated for South Jurors.
Spell your last name.
Jefferson, suffix Elbey.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, sir, pursuant to the Constitution.
All right, just keep your voice up.
Alright, this is, do you have his, oh, swear the other one
Yeah, left hand on the Bible, raise it right. State your name for the court.
Absolutely.
Spell your last name.
L-O-P-E-D.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right, just keep your voice up.
in? Alright. Defendant filed a number of motions. I've read them all. There are two subjects that I am interested in hearing about. First was a check drawn on Bank of America for $5,000 and some dollars. Mr. Elbay, which of these motions did you have that attached to?
That was my actual motion. It was dated 11/18/2018, made out to the Department of Treasury in lieu of my Sister Quay account, i.e. trust account.
11/18/2018.
2018. That's the CR instruction.
And that's made, and that was for how, for $5,000 and
$900.
$900.
Yes. That in lieu of the.
Would you hand a copy of that to me, just so I don't have to dig it out of here? Just hand it to the officer.
It should be in my file. Do you have it?
I have it, but I'm trying to find it.
Your Honor, I think-
I just want to have it in front of me.
And this
I'll
was
give
said-
this right back to you.
Certifies mail
Okay,
return
now I
receipt.
remember which one this is. Okay, let's see.
With the actual 1099-A form attached to it in lieu of my Sister Quay account discharge.
All right, so... Yes.
And I have.
Okay, so it's made out to the Department of the Treasury for Woodhaven Terrace for $5,903.77. Now, and it's drawn on Bank of America.
It was drawn to the Department of Treasury for Woodhaven Terrace, not Bank of
No, it
America.
says pay to the order, Department of the Treasury for Woodhaven Terrace.
Yes, it was not drawn on the Bank of America.
Well, that's what it says on the check, Bank of America.
That the check is from Bank of America, which my account is held there, but it's not drawn on the public side. It's drawn on the private side in lieu of my Sister Quay account, because as I stated,
It's based on your Sister Quay trust account?
Yes, sir, as I stated.
And that's the Sister Quay trust account, that's all your Social Security money?
Yeah, it's associated with my so-called birth certificate. Birth
Okay.
certificate is a trust
So
account.
this check, who'd you give that check to?
I sent it to the court, as well as sent it to the plaintiff.
The original check was sent to who?
The Department of Treasury.
You sent the original check to
To the
Department
Department
of
of
Treasury.
Treasury. And I have no objections or any,
So what did Department of Treasury do with it?
Yeah, and apparently they must have cast it, because I had no opposition, or have I heard from the Department of Treasury in lieu of that presentment.
Pay to the order, Department of Treasury.
And
So what does that mean?
It means that pursuant to the laws of GAAP means.
Generally accepted accounting procedures. yeah.
Exactly. So when I try my credit, it actually creates the actual promissory note, which according to Article 1, Section 10, you can't make money. It's created by way of my signature. So now, according to the Department of Treasury, this is the only department that creates legal tender, which is a violation of Article 1, Section 10. It clearly says that the only way to pay debts is with gold and silver.
Yeah.
So if the defendants, that's why I sent it directly to the Department of Treasury to pay to the actual plaintiff.
So you sent this to the Department of Treasury?
Yes.
Was there a cover letter with it?
It's all up there.
Okay.
And there has been no objection to that.
Hold on.
As instructed by the judge when you first have the hearing, they make the same statement, please make your checks out to the Department of Treasury. And that's what I did, and you instructed me at the last hearing to make my check at the Department of Treasury, for the record, on the record. Now,
I said
follow
that.
your procedure and pursuant to your certification of relief, filed on December 11th, you granted me a stay pursuant to those points I brought forth in lieu of them paying check.
Well,
And-
I granted this, because normally we don't issue, sometimes a warrant's issued ahead of time, but normally there's no, we don't do an eviction in this county while there's pending motions.
And
That's
pursuant-
why I issued this. And actually, I know that the, over in the clerk's office, they had planned to not issue the warrant until something was, until somebody in authority had allowed that, and that didn't happen, so.
And pursuant to,
So anyway, but wait, let's talk about the check here. So this check, let me see.
Your Honor, just for the record, I'd like to object to that last
I
characterization.
have
Well,
to
last
give my
character-
objection
About the
first.
court's instruction that the tenant pay money after the last hearing to the Department of Treasury.
I don't recall that, in
Yeah,
all
I don't recall
honesty.
that either, and I think the court's
Your
very
Honor,
clear about
objection.
where the money.
Well,
is
look,
paid.
I guess we can go back and listen to what I had to say, but I didn't put that in my order.
Your Honor, you
Did
said
I?
for the record, based off the certification made by the application, it's appearing that a warrant of stay is appropriate in lieu of those motions, by way of the fact that in my certification for relief, I said that the actual plaintiff and their attorney has not answered my answer, as well as responded to my answer, as well as my counterclaim. It was filed for the record. and-
Okay.
So they're in default.
This is all I need to know about the check.
Your Honor.
Thank you.
My object, because once again, I have no defense now. You have certified my relief in lieu of my motions that have not been opposed by the plaintiff. He has, according to the motion packet, it says that you must object in 10 days. Failure to object would be a notice of default. They had not responded to any of my motions. I got 7 motions on the record
Yeah.
that they had not responded. They have not sent me nothing in certified mail return receipts, so therefore, I have nothing to defend. Your certification of relief was based off the motion that was on the record, and that was pursuant to their response. Their response has not been noted, there's no proof of service, and therefore pursuant to the procedure rule governing affidavits supported by evidence, when in lieu of defaults that pursuant to the procedure rule, judgment is warranted. So my last motion on the record is demand for judgment pursuant to the procedure rule, in lieu of them being a default for not responding to all my affidavits, as well as my answer, which clearly the plaintiff and the clerk tried to hide, because I filed it, and I sent it to the court, I sent it to the plaintiff and their attorney by
Who tried to
certified
hide
mail
what?
return
Who
receipt.
tried to hide what?
The clerk.
The clerk tried to hide what?
The fact that they were served with my answer and counterclaim, which was
No,
filed.
that
for-
was not hidden by anything, by anybody. Nobody
Say it
hid that.
again?
Nobody hid that.
Yes,
I knew all that. That wasn't hidden from me, and I'm the only person who needs
Well,
to know
I
about this.
appreciate that. It wasn't hidden from you.
It wasn't hidden from me. It wasn't not hidden from me. It's all a matter of public record. They
Yes.
were served with that, and they didn't file it. You know, they did file an answer, a
I didn't get
two-page
that.
answer, which they faxed over. Then they
Objection.
we got a hard copy.
I didn't get no copy. I don't know
I
what
don't
they're
know
talking
either,
about.
but you know, it wasn't a particularly responsive opposition, but they did oppose it.
Objection, Your Honor. All
What's it?
motions according to the packet must be objected to.
Your Honor, if I could
The
just
motion
break in for a
packet clearly
minute.
says that.
Wait.
You upholding your oath today, right, Your Honor? To the Constitution?
Oh, yeah. So
Article
what's
1,
now? What's the next thing you want to talk about?
I didn't understand. You
Your
said,
Honor,
oh,
just
yeah,
for the
or
record.
yes?
Your Honor, just
Of
for the
course I
record.
am.
can
Of course I am.
Just one.
All right, what do you-
I haven't finished my honor. I haven't finished my
Well,
argument.
he's objecting. Let me find out what his objection is. I
Sorry.
let you keep objecting
I apologize.
every 5 seconds.
I
I'd like to
apologize.
know what his objection
Sure,
is.
you're right.
In fairness, I need to hear
Well,
both
yes,
sides, do I
agree.
not?
I agree.
My
So?
objection, very quickly, Your Honor.
Yes.
First of all, we are now opposing and have at all times opposed every application made by the defendant that we are aware of. Now, the defendant tells the court he's got 7 motions pending. Up until Monday, I had seen maybe 1 of those, maybe 2 of them. I had to contact them because despite the affidavits of service that we received from the tenant, those haven't come to my office. I got a fax from the court on Tuesday or Wednesday evening with a stack of papers I've got.
So you didn't get all of these?
Exactly. So
Objection.
we do oppose those, every motion and all the
All right,
future
okay,
motions.
okay. I hear.
Okay.
So now, the next thing...
Can I
I'm in-
respond to that, Your Honor?
Okay.
All right, in lieu of his so-called, his so-called reason for not responding pursuant to he so-called served, so he wasn't served.
Mhm.
I have certified mail return receipt saying that when he was served. So
Okay.
being that he wasn't served, that's not my problem. It clearly said it was stated. I have the return receipt saying it
Right.
was served. So they have an obligation to respond by way of affidavit, certified mail receipt, in lieu of the response. I haven't received any of them on all my 7 motions. My
Okay.
answer, my counterclaim.
I
So
hear you.
pursuant
I
to-
got it. Okay, what's the next thing you want to tell me?
Pursuant to my certification, my last
Yeah.
demand for relief pursuant to the procedural rule, that
Right.
judgment should be awarded to me, being that all those motions were not opposed pursuant to the law. So
Okay.
the Fourth Amendment and the Sixth Amendment. You gave me my right to a hearing in the Sixth Amendment, and
Yes.
according to the Fourth Amendment, no warrant or judgment should be issued without probable cause under oath of affirmation supported by affidavit. I don't see any affidavits here. I don't even see an oath. Swear that under oath of affirmation that you have not received a certified check made out to the Department of Treasury to you. Can you swear under oath for the record?
Your Honor, I have a witness here who is ready to testify.
Could she swear
As
under
to
oath?
all-
Wait, if the witness is under oath.
Okay.
If you'd like the witness to swear under oath whether or not she got something from the Department of Treasury, we'll let her talk, right?
Yes, and pursuant to also.
Could we just do one
Wait,
thing
wait,
at a
wait,
time?
wait.
I'm talking,
Do
sir.
you want the witness to talk or don't you?
I just want to finish my statement before she
Well,
talks.
finish what you're saying.
And pursuant to Article 1, Section 10, which you said you're upholding in lieu of debts being only paid by gold and silver, I discharged the debt because I have the right to create
Objection, Your
instrument,
Honor. These
which
issues
I
have
did.
been talked
This is-
about ad
This is the
nauseam.
law.
They've been ruled on
I
by the
provide-
court. We have, Your Honor, I'm sorry, but we've wasted enough time talking about the
Objection.
gold standard and the history of the United States. The court
History
gives
is
no
no
Actually,
instruction.
folks, listen. I have all the information I need about the gold standard to decide that portion of these motions. If you folks will let me, there's a second thing I want to know about that check. Now, the other thing I want to know about, you had made reference to, it's a certification on a complaint. Where would I find that?
That's when you make a reference to, Your Honor. Probably I can help you out.
Okay, one of your motions talks about no signature and seal. And nothing in there by the signature and seal of Michelle Smith was missing. What would you like to tell me about that, sir?
Pursuant to signature and seals on all orders issued by, from the court or any party pursuant to the Fourth Amendment, it says that a warrant should be issued, a warrant is an order without probable cause on the oath of affirmation signed and sealed or waiting them both sealed. All your order, if your order was valid pursuant to my request for
Now,
certification.
which order are you talking about?
Your order that
The one
you
I
did
handed you
on
the
December 11th.
couple weeks
No,
ago.
yeah.
That
That
one.
order that you get, I filed a motion in lieu of it not being signed and sealed. So it's a motion. They have not opposed it. So failure to oppose the motion is admitting that that was right. And pursuant to my request for certification of relief, that was mentioned in lieu of that order, and I filed a motion on the same day. You granted me relief in lieu of them opposing that request, because according to the warrant of removal, I also gave you the statute that says that a warrant of removal can only be issued by an officer if it's signed. And it was not signed. I brought that to the clerk office. You granted that stay. And they have the right to oppose that. I gave them the right amount of time. If they feared that their argument was valid, produce the law that overrides that statute. They have not done so. So nothing has been imposed by the plaintiff, who they represent, in lieu of any motion in lieu of the law. I produced the laws to support that. So failure to produce an affidavit under oath of affirmation supporting that is default. Now, pertaining to my last motion filed on the record, in lieu of your certification of relief, in lieu of your December order, that I have the right for those motions to be heard, which have not been opposed by way of affidavit according to the law of the Constitution, which you said you're upholding, in lieu of the Fourth Amendment, as was Article 1, Section 10, pertaining to gold and silver, pertaining to debts, in lieu of the, as well as the commercial code. So now I gave you the United States Constitution, I gave you case law pertaining to First National Bank, dealing with, and Jerome Daly, issued by Judge Mahoney, in lieu of gold and silver. So now this is a precedent case in lieu of a right as a trustee to protect my substantial right in lieu of my protected from the Constitution. I also produced for the record Legislative Bill 3823, which clearly says that the laws pertaining to corporations do not pertain to natural persons, and the government has a right to regulate corporations. I'm not a corporation. The lease shows you that I signed as a natural person.
Objection, Your Honor. This
There's
has
no
all been
signature
ruled
on the
on
lease
already, Your
by
Honor.
the so-called owner of the corporation, because as I stated in my last hearing, you asked me, so who is the owner? I said, I am the landlord. There was no objection from you, there was no objection by the witness, and there was no objection by the attorney. So therefore, the record states for himself that there was no objection. The affidavit supports that I am the landlord in lieu of the historical law pertaining to jurisdiction in which the state of New Jersey gets their authority from.
Your Honor, I'm
There has been
objecting
no
to this.
objection
I
to those.
understand your
I'm objecting to this
Counsel,
entire-
I'd like to hear from you on
Sure.
one issue.
Yes, Your Honor.
Somewhere in here, it was pointed out by the defendant that the complaint was, it's got the name of the clerk of special civil part, but it's stamped with the clerk of the Superior Court. You wish to address that issue?
I guess, Your Honor, I'm not sure. Are you talking about what?
Yeah,
what
there's
came from-
something in everything that the defendant said that would be a procedural defect. that
What
would-
came from the clerk's office?
Here,
All right,
right
I
on the
got-
front, right on the front. This is the complaint
Okay.
that you filed. And it's got Margaret Fidela Dish, clerk of the special civil part, as the name to, where something's to be stamped. And then over top of it, it's stamped Michelle Smith, Esquire, clerk of the Superior Court.
On that
It
issue-
appears to be alleged by the defendant that that's a procedural defect which avoids the complaint.
And can I make a point for sure?
No, I'm talking to him.
I apologize, sir.
Your Honor, the point that I would make is, in tenancy court, I can't find, I don't, if Your Honor could
Oh,
point
here.
me to the, if I could see Your
Here,
Honor's copy,
this
that'd be
is
fine.
the original copy.
Yeah. Okay, as in the wrong name is on there, Your Honor?
Right.
So, Your Honor, I would point out first that this is a court form that we're using here. First, that's my first point. Your Honor, my second point is, my guess is, this is not the only case in which this has been an issue. This is a court form.
That's the first time this is... Now, I know that we did get a directive from the Administrative Office of the Courts that the clerk of the special civil part wasn't to be the name on the complaint. It was to be the clerk of the Superior Court. That was to be the name that we had to put on it from here on out. And I imagined some lawyers in practice didn't get the memo and kept doing it the old way with their old forms. So, my question to you is whether or not this would constitute a defect that would force me to void the complaint.
I don't see why it should, Your Honor. There is no prejudicial aspect of that. Tenant has been on notice of everything here. I mean, judging by the court's instructions that, we're always given and are posted right outside this courtroom, there are really not that many issues to be talked about here. And yet, the money, the actual payment of money from the defendant to the plaintiff in actual valid funds is really the only thing we haven't talked about. Was there notice? Doesn't seem to be disputed. Everybody was here on the right day. Everybody heard the instructions. Everybody speaks English. This is a minor procedural issue, the wrong name of the clerk. I'd love
So
to...
you say this would fall under the purview of the maxim de minimis non curat lex?
I agree, Your Honor.
All right.
Correct.
That's what I wanted. Would you hand that back? That's part of our...
And I object to that, Your Honor.
I expect you to.
Yes, sir.
I want you to talk a little bit about that, and then I got a question. So you talk a little
Okay.
bit about the change in,
If I could just one more point.
one more point.
And my witness here brings this up. This is not the first time we've ever this landlord has brought a tenancy case against this defendant. So on top of what we just discussed, and this is the first time that we've ever had all of this back and forth, all of these history lessons, all these extra meetings and discussions. None of this has ever happened before. The tenant has always ended up paying in the end. But most importantly, the tenant has received that very form multiple times prior to this. I don't have the docket numbers,
Well,
but...
while we're on that subject,
Sure.
let me ask your witness, in the past, how did the defendant pay his rent?
He usually pays it online in the past.
Online?
Yes, on the website.
And the funds for the payment comes from where?
It would actually come from a bank account.
A bank account?
Yeah, or a credit card. I can't see that here.
A bank account or credit card?
Or credit card.
Bill of
yes.
exchange.
All right, okay.
But was it the...
All right, that's all right.
Okay.
Have a seat.
Okay, now,
Mr. Elbey, would you like to address the issue of the name on the...
Yes, Your Honor, I would
Yeah,
like to.
please do.
Pertaining to the so-called, because if you read on the actual warrant removal, it clearly says that only a court officer can issue a warrant of eviction. Way to stop that is to file a complaint, which I filed the motion in lieu of that order, because you stated by way of your signature that any unlawful eviction can be once again is a violation pertaining to law, and one can be put back in. Now, according to the procedural rule, New Jersey statute, NK 2A42, which 42-10.16 warrants of possession for execution, it clearly states that the statement shall also be affixed to the door to the unit to which the warrant applies. The statement shall identify the warrant, the date of issuance of warrant, the court and judge who issued the warrant, the date and time of execution, the warrant, the name, signature, position of person executing the warrant. First of all, it has neither of them. No date, no time, no affidavit supporting it, no signature of it. It has somebody's name printed, but that's not a signature. That's a violation of the United States codes, it's a violation of the United States Constitution, because they're not valid. So now,
The signature stamp doesn't count.
the signature is not, no, because
It's
why?
not a signature, because somebody
Because-
didn't actually sit down with a ballpoint pen and sign it. That's your position.
That's my position, it
Okay,
must be
that's
signed
all
and
right.
sealed.
You did-
I'm not, and also, once again, pursuant to what they call criminal simulation made by the court, because they're trying to hide this fact that when I objected to the motion to vacate your signature because it was not signed by the clerk, if that so-called issue was invalid, you would not have granted me a certificate of relief. Why? Because you granted it on the object, that being that the plaintiff object to that affidavit, my motion to vacate.
That's not why I
prior to signature.
granted that relief.
I understand that, but what I'm
I
saying
just
is-
told you why I granted it. I
Because
mean,
they have the right
it wasn't-
to
That
oppose.
wasn't the other reason, it was the reason I told you.
There's
I
the
granted
mo-
the relief because
The
you
motion.
had a pending motion.
Exactly.
And I didn't want an eviction taking place
Mhm.
inadvertently
Yes.
while your motion was pending.
Exactly. And
That's
pursuant-
why I did that.
I understand. And pursuant to the motion packet, it clearly says that failure to respond to a motion, that the court will rule in favor of you, not in favor of you. Why? Because you had a lawful amount of time to respond to every motion placed on the record. I answered my answer, my counterclaim, my motions to vacate, my motions of defaults. There's no opposition from the defendant. As I stated in my last motion for judgment, demand for judgment, because based on his certification, there was no opposition in lieu of the certification relief posed by the plaintiff nor their attorney. So based off that, the procedural rule states that if there's no opposition, default is warranted based off my affidavit, which is supported, my motion is supported by affidavit, which is how it's supposed to go. I clearly satisfied. So the burdens are satisfied. The burdens now shift to the plaintiff, which according to your certification of relief, it must have been warranted because there is no response supported by affidavit under oath of affirmation pursuant to the Fourth
I got
Amendment
a
of the
question.
Constitution.
Now I got a question. I got to make a couple more. Now you said before that since 1933 there is no money anymore,
Yes.
and that the little green pieces of paper in my wallet that got pictures of dead presidents on them, that's not money. They're Federal Reserve notes.
They're negotiable instruments. They're negotiable instruments.
Okay, but
And-
now
Let me explain.
the term you gave was Federal Reserve note. And it says that's what it says on it.
Say it again?
Right?
Say it again, sir?
They're Federal Reserve notes. That's what you told me last time we're here.
Yeah, the Federal Reserve note is not an instrument that you can pay a debt with.
No.
According to the Constitution.
Okay,
So the
because
only
it's
way
not
you-
gold and silver.
Because it's not gold and silver.
Okay, now, all right, I understand the whole gold and silver.
All right.
Now, let me ask you this. When you go to the grocery store to buy something to eat, how do you pay? You pay them with gold and silver?
No, sir, Your Honor.
What do you
You
think?
have the right according to the Constitution,
Right.
and once again, we are all ignorant, because once again, the plaintiff has said that he don't understand where this law is coming from. So at one time...
Objection, Your Honor.
At one
Objection.
time...
I have not said
objection.
that.
At one time, due to my ignorance, that I was left up without no remedy to do that.
Okay.
But now that I understand laws of commerce supported by laws to support what I'm saying
Right.
in this courtroom, the objection to that right supported by law, supported by affidavit, has now been rejected by the plaintiff. I'm only following the law, Your Honor.
Now,
anybody
you're not
can be
answering,
ignorant,
you're not
Your Honor.
answering, be quiet, I want to get my question in.
Uh,
My question is this. When you buy groceries, what do you use to pay for it?
Your Honor, once again,
I mean, do you write them in
Your Honor.
IOU? Do you write them in negotiable instrument, or do you use?
You
or
can
do you
write
use
it-
Federal Reserve notes?
you can write
What
in
do
the-
you? What do they accept at the grocery store when you need to buy some food?
you can write a negotiable instruments.
Like what?
Well, a check or
So you
money
write 'em a
order.
check?
A check or money order. Now,
So, do
whether
you give them
there's
a check or do you give them a money order?
a check or money order, I don't do the shopping. My wife does the shopping.
Your wife does the shopping.
My wife does the shopping.
So
What
you
she
know,
does,
so you don't know what she uses for.
I don't go shopping with her.
Okay.
My
So
argument.
do you
Your
ever
Honor,
have to buy
Your Honor,
gas or anything? Do you
Your
ever-
Honor,
you ever-
once again-
Do you ever have to buy anything in a store?
Are
Or does
you-
your wife do all of that?
I
for
have a
you?
question for you, Your Honor.
No, wait, answer my question.
Because the argument, I don't have a problem with you. It's left up to the plaintiff to argue this matter. He's not doing
See,
that.
Objection, Your Honor.
I just want to get an idea of what you consider to be payment. And
According
that's what I'm
to-
not clear on.
the
I mean,
payment-
if there's a way to get your debts paid
Yes.
by writing a check instructing the Department of the Treasury to pay ShopRite for, a couple of cans of tomato soup, well,
That's how it's supposed to be done.
that's how it's supposed to be done.
That's the law. That's the law.
Is that the way your wife does it?
I don't know,
You
but
don't
if
know.
it's of the law, it's no
Do
excuse.
you ever have to pay for anything in the store, or do you just delegate all that to your wife?
Once again, Your Honor, as I stated for the record, so to my ignorance, I didn't notice that one particular
didn't know
time.
that.
But
Well,
now
maybe you
that
did it
I
one time.
understand law, I follow the procedure governed by the...
Now you say, before
Honor,
maybe
let me-
you used Federal Reserve notes in the past, but now you've discovered what the law is, and from here on out, you're just gonna have the Treasury Department pay your bills.
That's what the court does. The court says make your check out to the Department of Treasury. Now, once again, I'm only following what the
Objection,
law
Your Honor.
says, Your Honor. You swore to uphold the Constitution. It clearly states that only gold and silver is to pay
Okay.
debts. So now, I'm only following instructions that the court, what the law says and the Constitution
right.
says.
Okay.
Anything, can I finish? Your
Yeah,
Honor?
go ahead. I'm just gonna ask you to finish up.
Okay,
Finish up
so-
everything
so-
you wanna
so
say.
what-
I got a couple of things, and then I'll...
So once again, I'm not here to defend anything but my motions that were not opposed. It's their job to
Objection,
oppose
Your Honor.
what I stated in my affidavit. So now, I'm just making sure that you uphold and don't assist the plaintiff in their so-called arguments, because that's violation of law. It's not equity, it's not fairness. I submitted my affidavits, they was not opposed, I followed the courtroom procedures, I followed the Constitution, I followed instructions in lieu of the Constitution in gold and silver. They didn't oppose that with valid law, supporting why I shouldn't go by the Constitution. I even stated in my last hearing, what species are you requiring me? They never said negotiable instruments.
Objection,
Are you
Your
saying
Honor.
negotiable instruments, Your Honor?
Objection,
Could you
Your
state that for the record?
Noted for the record, Judge.
Thank you.
So you're not allow him to explain what type of instrument he requesting, i.e. species?
It says it right in the instruction. The court said it 20 times. The tenant was here.
What
Money
type of-
orders.
Wait,
cash,
I'm not sure what your
certified
question
check.
You
That's it.
stated in your order, that you gave to me?
Yeah.
Off the record, that was not on the record, because you handed it to me.
No, it was on the record. Everything that happens here is on the record.
Okay, so in
This is
lieu of
on the
that
record.
motion.
Everything that happens in this courtroom is on the record. While I'm
Okay.
here, and that little blue thing is on the record, it's all being recorded.
But when I asked you for your order in lieu of the last hearing, I stated, would you state your order on the record? You said I handed it to you in writing. So that's why I'm requesting.
Right, it's handed to you in writing. It's on the record.
So now the motion, I also put a motion for the transcripts in lieu of your orders.
Yeah.
Is that motion granted?
What motion?
the motion for transcripts,
The motion for the transcript is not supposed to be decided by me, it'd be decided by another judge.
is not supposed to be decided by you.
No, not supposed to be decided by me. See, if you want to appeal the appellate division, you got to get transcript, okay?
I'm not
Wait,
appealing.
let me explain. See, if I were to, let's say I make a decision, you don't like it. I want to appeal you, Judge Corman, and I want a free transcript. Now, if I deny your motion for a free transcript, that messes up your appeal.
Yes.
So it would not be proper for me to decide your motion for a transcript. Now, there are certain legal requirements that have to be met in order to get a free transcript, and that's really something for the other judge. That's
Yeah.
why, see, it's up to me, I let everybody have a free transcript, but that's not, but I can't do that.
Yeah.
See, when I make a decision, I'm confident it's going to stick.
Yes.
So you want to take me to the appellate division, that's fine by me.
No,
I
I
don't
don't
care.
have a problem with
I don't
that.
care what that, but you see, that's why I'm not supposed to decide the transcript motion.
I understand.
Because it may be that you have not met the legal requirements for a transcript motion. Free transcripts are commonly granted in criminal cases where there is a consequence of magnitude, but they're not common in civil cases.
Yes,
Now, I'm not going to get into that because I don't care.
Because I have to.
But I'm not. But that's not my. That motion is not before me.
Your Honor.
That's
once
the
again,
reason why.
Once
Somebody
again,
else will decide that.
My motion, everything I'm requesting in lieu of all the argument is in
Right.
lieu of the Constitution.
Yeah.
The right, according to pay debts, according to gold and silver.
Right.
The right to be heard, and the way, in lieu of warrants not being issued without probable cause on the oath of affirmation.
Mhm.
These are all constitutional remedies that me as a citizen have a right to, which you just said for the record, on the record that you are supporting. So now, if you're not going to grant me the rights what I'm asking in support of the Constitution, could you please state the record, what laws are you using to support
Okay.
your...
I will. I'll state everything for the record. I'll
Okay.
state everything as to why I'm deciding everything.
And,
Now, is there anything else you want to say?
yes, once again, in lieu of my argument, I demand for judgment of possession in lieu of all the complaints that I filed in lieu of motion that had not been objected to by the plaintiff, as well as my answer. The court has these documents in the file.
Mhm.
I followed the proper procedure. They were certified return receipt, and that the plaintiffs have not opposed them. So
Okay.
in lieu of that, according to Procedure
Again,
Rule
objection, Your Honor.
1:6, 8, I have the right to remand the judgment for default.
Okay. Thank you.
Your Honor.
I'll give you 10 seconds.
Okay, I'd like to hear the rule under which the defendant filed his answer to the landlord's, the landlord-tenant his answer to the complaint. There is no rule. There generally aren't answers and counterclaims sent in writing in landlord-tenant cases. These are different cases. Obviously, the court knows this. The tenant should know. If he had the money right now, the court would probably make us take it. Because
I
it's
would.
simple. This is, I mean,
Okay.
this is...
I've heard
insane.
enough, Counsel. Have a seat.
Thank you, Your Honor.
Okay. Bottom line here, I'm reserving decision. I'm going to provide a written opinion, and I'll explain why it's going this way. First of all, on the issue of things for which there is no, formal opposition has been filed. Okay. The policy of New Jersey courts, this is set down by the state Supreme Court, is that the policy of the judiciary is to favor resolution of disputes on the merits as opposed to by default. I think that's the Martyr Realty case, but there's a whole line of cases. We favor resolution on the merits.
Okay.
Now, let me finish.
Go ahead.
Okay. Now, just because something is unopposed doesn't mean a court needs to automatically grant it, because if something is unopposed but it's clearly contrary to some statute, the court must not grant it, because the court has to look at the law. Now, there is a rule, there is a court rule that says there are no counterclaims and answers to be filed in landlord-tenant cases. I didn't make up that rule, the state Supreme Court did. Now, I will cite the rule when you get your decision.
I need that on the record, Your Honor.
I will give it to you on the record.
Could you state it right now for the record?
I did state it on the record.
Please, I'd like to hear it. Because, and that does not override the Constitution, Your Honor.
Objection, Your Honor.
Wait.
That don't override the Constitution.
What?
The Constitution clearly says that.
Mr. Elbey,
I'm only-
I can't read so well when you're talking to me at the same time.
But is that the
If
Constitution?
you would like it on the record,
Yes, Your
you
Honor.
need to be quiet a little bit, so I can cite the rule.
I will,
Would you
but-
let me look this up?
I have
If you
done-
want me to do that, you need to be quiet.
Yes, but Your Honor, I need to state this in lieu of you looking at this rule. Is that
But do
rule-
you not want me to look at
Yes,
the
I do. Yes, I do.
You
But
do?
Is it uniform?
Well,
with
then
the
why
Constitution?
you keep interrupting me?
Because there's different rules, Your Honor. I want to make sure it's
well-
uniform with the Constitution. Is it uniform?
Well, let me set you the rule before you go citing the Constitution.
Fourth Amendment.
The Fourth Amendment does not pertain to judgments by default. Let me see here.
Could you hand this to the judge?
Pleadings and motions.
This is the case dealing with Judge Mahoney.
I read that.
Okay.
He's a
That's-
justice of the peace out or he was a justice of the peace out in Minnesota in 1960s.
Yes.
I read that.
And that laws applies to me.
Objection, Your Honor.
In lieu of my
Objection,
constitutional
Your Honor.
rights. There's nothing to object to, that's the law.
Your Honor, this will go
That's the law.
on forever. If the
Guys, I'm
defendant-
never going to find this if you keep interrupting.
I'm happy to stop, Your Honor.
Applicability, endorsement of papers.
And Your Honor, 1 second. Judge Paulin,
Yeah.
who works for Superior Court, he actually granted a remedy in lieu of the right to proceed without paying in lieu of Article 16010.
Objection,
She's in
Your
this
Honor.
court. This is my brother Syed Bey. I actually filed a copy with that in Chancery Court, which they have it on the record, in lieu of her granting the right pursuant to the constitutional right. Judge Paulin. So this is all recorded for the record. This is the brother. Since I don't have a copy with me, but it's filed with the Chancery Court, in lieu of that order that she granted my brother Sadiq Bey the right to proceed pertaining to the Article 1, Section 10. So this is another judge who's also the trustee who act in the fiduciary duty that you do, which so it should be uniform to follow that suit in lieu of your obligation to the Constitution, Article 1, Section 10, which she clearly granted.
Again, Your Honor, I'm objecting to the defendant's last monologue.
And I can also send the court a copy of that. Your Honor. Just court. Your Honor.
Yep. Rule 6:3-1. No answer shall be permitted in summary actions between landlord and tenant or in actions in small claims section. And a counterclaim is deemed an answer.
Your Honor.
Now, you could file a separate complaint against them for all those
Your Honor,
things,
for
but
two-
you see, but look.
I have to-
That's how, now, there's another thing I want to talk about, and that's this. You
Can I
see-
respond to that?
No, 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 no.
I'm-
No,
I'm-
no,
I'm-
no,
why?
no, no, I'm gonna tell you, you need to listen for a second. I've let you talk for a long time.
But
Now, I get to have my say.
I understand that.
Now, and I'm gonna consider some of your stuff. Now, one other thing is the issue on gold and silver. Personally, I think the Constitution's pretty clear. There's nothing but gold and silver can be legal tender. Now, the Supreme Court has decided otherwise.
If
The
the
Supreme Court, the United States Supreme Court outranks me. Now,
It don't outrate
so
the
I
Constitution.
can't overturn the Supreme Court.
No, the Constitution, Your Honor.
No, I can't, but I am bound by their decisions.
You're bound by the Constitution.
Yes,
You
I
didn't take
am.
an oath to the Supreme Court.
I'm bound by the Constitution as interpreted by the Supreme Court. I
But
may
the-
disagree with their interpretation.
Exactly,
But
because the
I am
Constitution
bound by
stands
their
alone.
interpretation until someone goes up to the Supreme Court and convinces them otherwise.
Yeah,
But now, this is what I'm going to do.
Could I
One
just
issue,
mention legislative
the
bill
one
3823?
issue, there is one issue that I need to address, and that's the issue of the complaint, and whether or not the right signature was on that, now, there may very well be case law that says,
Stand back.
this is a harmless error, it's nothing but I've not been supplied with anything like that. So what I have to do, and by the way, I really like all the stuff you provided about New Jersey's colonial period. I really enjoyed reading that.
And I have a right as an Englishman, an English noble, national. I proved my status before the court. The statute of Westminister of 1285 proves that I have a right to be tried according to the laws that pertain to my protection.
Objection,
New
Your Honor.
Jersey Revised Statute.
Actually, there is a section of the Constitution that no state may recognize titles of nobility.
Not title of nobility is my birthright. It wasn't granted to me. It was a right that was given to me by way of my heirship.
Right.
I established 1285 Statute of Westminster by Edward I. It
Right.
says that no transfer of land should be transferred other than the heir. I
Yeah.
have the right by way of my surname Jefferson. Jefferson is actually in Old English is Godfrey. That law is protected by the Statute of Westminster. He used the modern day statutes. I'm using the old day statutes. American
Well, I
law is
understand
found
all
in
that.
English law. So as you read in Mahoney, it clearly says that the Constitution gets its authority from the Bill of Rights, which is authorized by the Magna Carta.
But
signed in
now,
1215.
the British Crown has not exercised sovereignty in the state of New Jersey.
I'm not part of the British Crown. I'm part of the Kingdom of England. New Jersey is not subject to the Kingdom of
Well, the
British
English Crown hasn't exercised sovereignty in the state of New Jersey for 200 years either.
Well, if you read my affidavit.
I have.
Well, it clearly
I have.
states
I've
that.
read it all. But look.
Your Honor.
Yeah.
I'm trying to prove my status.
I understand that.
Well, let me prove it.
Go ahead.
Okay, according to the law of the United States Constitution, where Superior Court gets its law from 1947, its authority comes from the Constitution of 1776, was given to them by Queen Anne. Prior to that, they had separate constitutions.
Yeah.
Because she clearly told Viscount Cornbury that it's supposed to be fusion of government overlapping. This is the structure from Queen Anne, which was then called the Kingdom of England.
Yeah.
On my application, I'm a citizen of the Kingdom of England. They can use that corporate name, but this is actually Bailiwick of Jersey. You accept my motions filed pursuant to my domicile. So I have right to, pursuant to New Jersey Revised Statute 3-301, I have the right, according to statute, use whatever law of my nation to protect my due process of law. It's in the affidavit. So I'm using that particular law to support my rights pertaining to an English national. So the laws you're using to support the plaintiff's argument is unconstitutional because it denies me of equity. Laws are built off equity that goes back to England. So you being a trustee, according to the laws that were governed by way of the Supreme Court, Supreme Court, it clearly says in Title 18, 2072, it clearly says that any law that violates a substantial law is null and void. This is from the Supreme Court, 2072. It's in the affidavit. So if you just said you have to follow the law of the Supreme Court, it clearly says that any law violating my substantial rights, which is in my affidavit, that becomes null and void. So pertaining to the laws of the Supreme Court, which is passed down by the Judicial Conference. The Judicial Conference actually were derived from England. So these are the Judicial Committee who sets the standard for the Supreme Court, passed down to all the courts. That's law, historical law. Plaintiff had a problem with that. It's in the affidavit, and pursuant to that law, I have the right to be protected to that law. To use any other law on me in lieu of that substantial protection is null and void. And you have the right to protect as you swore under the Constitution.
Well, I will consider all that when I'm preparing my decision over the next week or so. Thank you very much, gentlemen. Have a wonderful weekend.
Thank you, Your Honor.
Happy New Year to both.
You too,
Thank
sir.
you, Your Honor.
And mine today is Blue Christmas. You know that, right?
That's what?
Blue Christmas. It's called Forefathers Day.
Oh, really?
Yes, sir. It's when the so-called Mayflower Society and the so-called Old Colony Society were actually Puritans who were broke away from England.
Yeah.
On this day, particular day, December 21st.
Okay.
Yes, look it up, Jan.
I will look it up. Thank you very much.
You're welcome.